Today, we are honored to have a distinguished panel comprising legal practitioners and also maritime industry experts who will be deliberating on the suitability of alternative dispute resolution mechanisms such as mediation and arbitration for maritime disputes. The panel discussion will be moderated by Mr. Lee Wai Pong, an industry veteran whom I've known for over a decade. Mr. Lee Wai Pong founded LWP.SG Consultants in 2016. He is currently the regional advisor to Thomas Miller Group, which is the manager of the UK P&I Club. Mr. Lee went to sea in 1974. To date, his career in the maritime and dispute resolution industry spans nearly 50 years. Mr. Lee was previously the executive director of SCMA for 5 years. He's currently today both an arbitrator as well as an SMC principal mediator, accepting appointments for both ad hoc and institutionalized arbitrations and mediations. Mr. Lee is also a regular adjudicator at Singapore's Financial Industry Dispute Resolution Center, and he is a consultant on claims management and strategy. With that, I would like to hand over the time to Mr. Lee Wai Pong. Mr. Lee, please. Thank you.
Thank you very much, Bernice, and warm welcome to every one of you tuning in today. My connection with SCMA is not alone. Actually, as I sit here, I'm reminded that I'm surrounded by SCMA alumni, and most prominent one of all being Dato Jude Penny, who is tuning in from remote today. Jude led the team that actually formed the SCMA back in the late 2008. So most of us have connections with the SCMA from the nascent days until now, and it's so nice for all of us to be here today. The title, as Bernice mentioned, for today's webinar is Mediation of Shipping and International Disputes, Singapore's Role in Maritime Dispute Resolution. So the title is a double-barrel one. The first topic obviously circles the role and capability of mediation to resolve shipping and international trade disputes. And the second one focuses on how Singapore dovetails itself into this conversation. Let me talk about the journey of ADR in Singapore. ADR is actually short for Alternate Dispute Resolution. Some cynics say it's an alarming drop in revenue for many lawyers, but that's not true, of course. The formalization of ADR process in Singapore is a relatively new development. In Singapore's legal landscape, most disputes in the early days were litigated in the courts before the emergence of ADR. And as far as exposure to ADR is concerned, the majority of disputants were rarely exposed to the world of arbitration or mediation, unlike today's world. And Singapore's entry into ADR, you could say, came with a bit of a whimper, but currently it is a roar, a loud roar when it did. In true Singapore style, we punched a hole in the roof and reached for the sky. So Singapore's journey into ADR is nothing short of spectacular ever since the decision was made to develop ADR. So we look at the album of Singapore's greatest hits in terms of ADR. I could rattle off things like the development of arbitration and mediation into mainstream forms of ADR as we know them today. The development of Maxwell Chambers as a world-class facility to conduct hearings. Institutionalization of administrative bodies such as the SIAC, the SMC, the SIMC, shipping and international trade. But perhaps amongst all these jewels, the crown jewel could arguably be the Singapore Convention. In December 2018, the UN General Assembly, by consensus, passed a resolution to adopt the UN Convention on International Settlement Agreement resulting from mediation. Quite a mouthful. The Council also recommended that the convention be known as the Singapore Convention of Mediation. And now we shorten it to just the Singapore Convention for short. And authorized the signing ceremony of the Singapore Convention to be held in Singapore on the 7th of August in 2019. And since then, this Singapore Convention Week, as we know it now, has become an important fixture in the legal landscape and calendar. I'm well aware that for the past 2 years, we have not been able to come together and celebrate SC Week. And I'm so pleased that we are able to convene SC Week 2022 with so many in-person or virtual events. Which brings us today to the webinar, one of the in-person events. However, I'm gratified to hear from Bernice that we have close to 700 participants who have signed up. So to all of you who are tuning in this morning to Singapore, welcome. Welcome and thank you for joining us. Let me move on to the webinar today. I would like to introduce our 6 learned speakers gathered to share their views on this topic. Their collective experience is at the very senior level, and it's also diverse in terms of industry. Put together, their collective experience spans more than a few centuries. So if one could visualize thirsty voyagers drinking at a small well of knowledge, today's session is more like drinking from a fire hose. It's a lot. So we therefore need to control the outpouring of knowledge and expertise. Now, the format of the webinar will be divided so that each speaker will speak on the webinar related topic of their choice for about 5 minutes to share their experiences and views. Let me move on to introducing our speaker. On my right, we have Mr. Bazul Ashhab. He's the managing partner and the head of dispute resolution at Oon Bazul LLP. Bazul specializes in commercial litigation, arbitration, and mediation. And that's not all of his talents, but I'm limited by time. And he has a broad experience across the spectrum of practice areas, which include international trade, banking, trade finance, insurance, insolvency, and shipping. He acts for banks, trading houses, listed and private companies in Singapore and the region. Bazul is very well regarded for his expertise in resolving cross-border disputes, and he has acted for clients from various jurisdictions in the Asia-Pacific region over many years, giving him the ability to combine his legal expertise with cultural considerations to resolve complex disputes effectively and practically. Next to Bazul is Mr. David Roberts, the Managing Director of Standard Asia. David is a lawyer qualified in Australia and in the UK with over 30 years experience in protection on indemnity, or what we call P&I, third-party liability marine insurance, where he has held senior claims and management positions. David is currently the Managing Director of Standard Asia's Singapore office, where he's also the CEO responsible for regulatory compliance. I'm so lucky I'm surrounded by 2 beautiful ladies. I'll start with Delphine. Delphine Ho. Delphine is the resident of the Arbitration Chambers. Before that, she was the registrar of the SIAC, or the Singapore International Arbitration Center, for 5 years, where she oversaw the administration of arbitration cases filed with the SIAC, in addition to supervising the secretariat there. And over at the Secretariat, she was responsible for the scrutiny and the approval of more than 800 draft awards and orders. So if there's anything that Delphine is not short on, is experience in arbitration. She started practice in one of Singapore's largest legal law firms and entered the Singapore Judicial Service in 2013, serving concurrently as an assistant registrar at the Supreme Court and double hatting as a district judge in the state courts. Welcome, Del. Next, my pleasure to introduce my old friend who's not seated here, but in his own office, Dato Jude Benny, a consultant at Joseph Tan Jude Benny or JTJB LLP. Jude jointly founded JTJB and is over 38 years, both as counsel and arbitrator, covering a wide area of commercial law, including shipping, infrastructure, offshore, shipbuilding, and corporate conflicts. But his experience actually extends beyond the law. Jude also served 7 years as director of the MPA, which is the Maritime and Port Authority of Singapore, which is the regulatory body for maritime transport sector, as well as 6 years as the director of Singapore Maritime Foundation. I don't know where he finds all that time. During that time, in addition to his practice, Jude acquired significant experience in the promotion and strategic planning of maritime cluster developments, as well as maritime ecosystem growth. Jude has accepted many appointments as arbitrator in the ICC, EMAC, SIAC, SCMA, KCAB, and BANI. So welcome, Jude, from where you are sitting in your office. Next will be Gho Sze Kee. Sze Kee is the LCC manager at the Shipowners Mutual and Protection and Indemnity Association Singapore branch, or widely known in maritime circles as the Shipowners Club. Sze Kee is a maritime law specialist with almost 2 decades of experience. She was called to the Singapore Bar in 2003 and gained extensive litigation experience in handling shipping and admiralty claims, whilst working with boutique law firms that also specialize in maritime law. Sze Kee is currently the legal costs cover manager at the SOP, a mutual that provides third-party liability insurance cover to smaller and specialist vessel owners, operators, and charters globally. And last but not least, who is also our host at today's premises, Mr. Nicholas Fell, the Executive Corporate Services and General Counsel to the BW Group. Now, Nick oversees the legal, insurance, and corporate secretarial departments of the BW Group, and is also a director of North of England P&I Club, an associate mediator at the SMC, and a fellow of the Singapore Institute of Arbitrators. Nick is the current chairperson of BIMCO's documentary committee. Prior to joining BW Group, Nick was the Chief Administrative Officer and General Counsel for American Eagle Tankers, or AET Group, whilst heading the legal, risk management, and compliance together with HR and IT there. Nick has multiple talents. He has degrees in law and business, and is also qualified in the UK, New York, California, and Hong Kong. So on that note, welcome to all of you to today's webinar, and we'll move on to the next segment of the webinar itself, which is where I will ask individual speakers to share with us for about 5 minutes the topic of their choice. I'll start over with you, Bazul.
Thank you, Wai Pong. So I am speaking on 2 topics. One is enforcement. The other is my experience dealing with mediations as a mediator, as well as mediation counsel. So let me start with enforcement. So think New York Convention. Before the Singapore Convention, when you enter into a settlement, if there is a breach, you need to initiate proceedings on the settlement agreement and progress your claim as the basis, which is that there is a breach of the settlement agreement, and that would have to be fought at. And depending on which jurisdiction, some jurisdictions have summary judgment process, which you can then use to avoid a trial on that dispute. With the Singapore Convention, what it does is it recognizes the settlement agreement and you can then enforce the settlement agreement as a local judgment in the country which has signed up, ratified, and signed up to the convention. As things stand now, there are 55 countries who have signed up, and 10 countries have ratified. So we are hoping that US will sign up fairly or ratify it fairly quickly. US has signed up, China has signed up. Once this major trading powerhouses signed up or ratified, then there would be greater enforcement. Enforcement is key. So think New York Convention. I repeat that the Singapore Convention will gain traction quickly. So think New York Convention. So New York Convention was signed in 10 June 1958, 64 years ago. It took a while for 166 countries to, out of the 193 countries to ratify it. Now, in Singapore Convention, we already have 10 countries which have ratified it over the short span of time. So I think there's going to be greater traction. We will see greater enforcement coming through. Now, I want to touch very briefly on my experience in mediation. Now, as a mediation counsel, what you need to recognize is that there is the human element will take a center stage in dispute resolution, as opposed to turning up before the judge and convincing him on why the facts and the law is on your side. Here, as a mediation counsel, what you're doing is you are convincing, you have an opportunity to engage the other side's principal, as opposed to the lawyer, and have him recognize that it is what you are proposing is a sensible way to resolve the dispute. Now, as a mediator, my approach is, speaking generally, shut up and listen carefully. Because if you shut up and listen, you observe the unspoken words, and they have a bigger impact than the spoken gestures. So you observe deeply, and you have an idea as to who is making the decision, and you then approach your facilitative role more effectively. So that's what I find it useful as a mediator. It's another element, confidential. You got to have parties repose trust on you. And if you fail in that process, you would be an ineffective mediator. So, I mean, those are my comments on the two areas which I've chosen to speak.
All right, thank you very much, Bazul. It's really interesting about what you mentioned about the speed with which the Singapore Convention is gaining traction vis-a-vis the progress of the New York Convention. I mentioned earlier that we try to punch above our weight, and I think this manifests itself. Let me move on to our next speaker, David. David, would you like to share with us the topic of your choice?
Sure. Thanks very much, Wai Pong, and good morning to everybody. Yes, so I have a number of topics I'd like to briefly cover. The first is just to set out the role of the P&I Club from a mediation perspective, and the interest of the P&I Club as a user of mediation. Now, first and foremost, clubs are the creations of the ship owners themselves. We are mutual organizations, ultimately beneficially owned and controlled by the ship owners. So our interest in the P&I Club is very much aligned with the interests of the ship owners, charterers, and ship operators that we insure. In terms of what are we insuring, we are insuring, in the context of mediation, the legal costs and expenses associated with that mediation. Under the regular third-party liability P&I cover that we offer, the coverage responds to both the underlying liability and also the legal costs and expenses. As in the case of the FDD or defense insurance that we offer, the cover responds purely to the legal expenses. Now, it's important to say at this juncture that the insurance that we give responds not only to our own members' costs, but also the costs of the opposing party, insofar as our member has a liability to that under an award or settlement agreement. So why do P&I clubs like mediation? The short answer is that it is a highly effective method to resolve maritime disputes. Effective and efficient. Efficiency means bringing disputes to a speedy conclusion. And that is most definitely in the interests of our members, the ship owners and charterers. They don't want to be bogged down for years in messy litigation. And of course, litigation brings with it commercial hazard and risk. It is a destroyer of relationships. So mediation is a brilliant way of cutting through that. It also happens to be generally a lot cheaper, particularly if you commence the process early on. And this is going to be a key theme of mine, certainly, is the importance of early mediation. We call it in the club, we call litigation and arbitration the conveyor belt of litigation and arbitration. You know, the danger of parties becoming entrenched in litigation and arbitration, often for years on end. And before you know it, the legal costs often become disproportionate to the amount of the original dispute. Most maritime disputes are not huge, you know, therefore several hundreds, thousands of dollars. You occasionally get disputes, contractual disputes worth a few million, but the vast majority are in the hundreds of thousands rather than the millions of dollars. And as all of us on this panel know, it's very easy to get up in terms of legal fees, above $100,000 very quickly. And not only that, but if you lose, you then may have to pay the other side's costs if you're in common law jurisdictions such as the UK or others. And so that's a real danger. And then the legal disputes can actually become a hurdle to actually resolving the matter, because people say, well, look, the only way I'm going to settle this is if I can now recover all of my legal costs as well, because we've spent so much and it's become a matter of internal embarrassment. So why isn't mediation used more frequently? Now, this is something, it's a question that those of us on the club side, and I think many owners, certainly many ship owners and charterers ask themselves the whole time. If it's such a great thing, which most people you speak to seem to think it is, why isn't it used more frequently? It's a really good question. Clearly, you need buy-in. You need buy-in of all the stakeholders in the process. So that's not only the litigating parties, but also the insurer and the lawyers. Because typically, in many of these cases, lawyers would already have been instructed. Now, the usual refrain, and I have to say this is a matter of annoyance to many of us on the insurance side of things from lawyers, is, oh, it's too early to mediate. We have to let matters run their course. We have to let the evidence evolve. And you'll hear this from many lawyers, even years after a dispute is actually commenced. And so it begs the question, well, is there ever a right time to mediate? Is it always going to be too early? You know, a lot of the mediations that we see often occur extremely late in the process, sometimes almost on the door of the hearing. That has to be too late, in my view. Finally, what is our experience of litigation in the Standard Club? We're insuring about 9% of global ship owners. I'm afraid to say we see very few mediations. The good news is where we do see them, I'm not aware of a mediation that has failed. And if they don't settle actually at the mediation themselves, they tend to settle it in the weeks following the mediation. So in our experience, mediation have a tremendously successful track record. A senior mediator I spoke to in London told me that 95% of the mediations, and this chap is one of the key, most important mediators in the London market, 95% of the maritime mediations that he had settled. That's an extraordinary statistic. So we wholly endorse mediation. We very much welcome SCMA's and Singapore's enthusiasm to mediation. And as a Singapore-based P&I Club, we look forward to working with all parties here to make sure that more of it happens, hopefully.
Thank you very much, David. I'm quite intrigued by your conveyor belt concept. So, you know, if one could visualize mediation as the baggage handler, we obviously need more baggage handler to pull the luggage off the conveyor belt of arbitration to shorten the process. Delphine, your turn is up, and I'm guessing that you would like to inject some color of arbitration into the conversation. The floor is yours.
Thank you, Wai Pong. Morning, everyone. So as Wai Pong says, and he mentioned briefly earlier, my experience is fortunately or unfortunately largely arbitration related. So I'm going to share some of my thoughts about how Singapore has come today in terms of developing itself as an ADR center, and how shipping and trade disputes have featured in this growth pattern. The first port of call is obviously statistics, because we all like numbers, at least to a certain extent. So, and I think if you look at the statistics from the Singapore International Arbitration Center, they've been publishing it for at least the last 10, 12 years. What can be seen is that a really significant proportion of the arbitration cases seen at the SIAC are maritime and shipping cases, as well as trade cases. Trade, in fact, so trade cases as defined by SIAC includes disputes involving sale and purchase of goods and documentary credit. And when I went through the statistics for the purposes of this morning's discussion, what I did notice is that at the lowest point, shipping and trade disputes at SIAC took up 25% of the total caseload, and at its peak, which was back in 2020, it took up 70% of SIAC's caseload. So you can see that there is a significant representation of maritime trade and trade disputes in SIAC. I think at least having seen what's been happening in the last few years, trade disputes in particular are very much connected with how the economy is doing. There was a significant increase in the trade disputes in 2020, because if you think back to late 2019, 2020, there was a lot of economic uncertainty. There were the beginnings of delays in terms in shipping and manufacturing, and this really led to, I think, the significant uptick in such disputes in 2020. The other, and really these statistics are an underrepresentation, in my view, of the true extent of this nature of ADR in Singapore. Many maritime and trade disputes still continue under ad hoc non-institutional arbitration. So there's really no real way of tracking how many of such disputes we are actually seeing. One of the things, however, that I've been told, and this is anecdotal, so maybe some of the other practitioners and the clubs can add to this later, is that while historically LMAA arbitrations were seated in the UK, there have been an increasing number of LMAA arbitrations seated in Singapore. And again, I think that choice of Singapore as a seat for arbitration, for LMAA arbitration, is another indication or an indicator of the acceptance of Singapore as an ADR hub. So really, these present day statistics are reflective of past efforts because arbitration, just getting, for the purposes of arbitration, there are a lot of steps before a case manifests. You first have to get the clause into the contract, you need the dispute you need the contract to enter into a dispute, and then you need parties to be in a position to say, right, we're going to arbitrate or mediate or any form of actually taking steps to resolve that dispute through ADR. So that's really quite a prolonged process. I think that really looking forward, for Singapore at least, we've come very far, and I think the speakers before me, as well as Wai Pong, have alluded to this. Singapore has come very far in terms of how we have promoted and encouraged the growth of and use of ADR in Singapore. There is competition, and I think some of the competition that in the more recent times, you're looking at Hong Kong being added as the 4th arbitration center in the BIMCO contracts. You're looking at the amalgamation of the Emirati Maritime Arbitration Center with the DIFC Arbitration Institute. So there's a new arbitration institute in the UAE, Dubai, which is focused on trying to capture that arbitration ADR market within that region. So we're seeing competition coming from other jurisdictions quite a bit. I guess what more can be done, and I will just share like some views first, which is I think that there have been increasing criticisms of arbitration over the last few years. And I think that has contributed to the uptake of mediation. So I think that's a positive thing. And within the context of arbitration, there needs to be a re-examination, I think, of the arbitration process, the cost of the process, and the efficiency of the process. Those are constant criticisms that have come. And I don't think those criticisms are unfounded. I personally have had an arbitration run 12, 15 years without actually coming to a resolution. So yeah, I know it sometimes really takes a very long time. So I think those are some of the things that at least arbitration practitioners, arbitration institutions need to look at. And I think the final point I would make on this is, touching briefly on someone else's topic, is actually there's an increasing trend of amalgamating ADR options. So you have met up, you have up met up, and all that. And I think really there is a very large spectrum of ADR available. We talk about arbitration, mediation, but there's also adjudication, there's negotiation. So we're really looking at a broad spectrum. And the question is how to make use of these different options to create or arrive at the most efficient and cost-effective dispute resolution mechanism for users. I think I will stop there for now.
Thank you very much, Delphine. I think you've thrown up some really interesting talking points. I'd like to revisit on. But time is moving on. Let me move on to our remote speaker, Jude. Jude, would you like to share the topic of your choice with us? Over to you.
Yeah, thank you, Wai Pong. Thank you for the introduction, and thank you, SCMA, for having me here today. I'm going to be speaking something very closely related to what Delphine just spoke about. Basically, growing Singapore as an ADR center, and of course, there's the subline which says, "Where's the competition?" I actually don't like that subline because we're not in a competition with anyone. It's really about being relevant to the stakeholders and the people and the maritime and business community. They need to see, whether it's London, Hong Kong, or Singapore, this is the best place for me to go. It is the most material one, it is the most cost effective. End of the day, we're talking a very smart businessman who want to find a jurisdiction that is cost effective, and of course, it's the quality has to be there, right? So when we're talking about growing an arbitration center, and when we started this, you mentioned 2008, Wai Pong, in your intro. It's actually 2004 that when we actually started this whole idea of trying to get SCMA going, and it was all about the clause, because we're not going to have any arbitrations in Singapore. No one's going to write it in, right? So it was all about selling to the community, selling to the business community that writing in a Singapore arbitration clause was a good thing for you. And in that respect, of course, we were facing a situation where London had the predominant position. You can't argue with that. You've got over 2,000, 3,000 cases a year just in the maritime field. So it was not really about trying to take on London, but it was trying to offer, especially in the Asia-Pacific region. China was booming and people were trading. There's tremendous amount of tonnage moving in and out of China into the Asian region, Europe to Asia. So Singapore was, from a location point of view, a very attractive proposition. Add on to that the fact that we had the kind of infrastructure, both commercially and politically, that people liked. People like the idea that Singapore is a good place to do business, and so latching on to that, it was not difficult to then say that Singapore is a good place to come to have your disputes resolved, because there was transparency, things were efficient. I've spoken in so many conferences around the world, and people get very upset with me. Sometimes I go to some places, I say, look, how do you expect people to come to a country where it takes 3 hours to get from the airport to the city, right? So things like that need to work. And then people see that, actually, and that it's a good place. I know a lot of people like to go to London for arbitration because it's an opportunity to go to Harrods and do their shopping and everything else. But people also like coming to Singapore now. So all of these factors kind of fall in line. And so gaining traction was not a difficult thing to do. If the time scale is today, we are gaining on the traction that the good work that SIAC did, because SIAC really, sort of brought Singapore arbitration to the attention of the world. So from there, it really, it's not rocket science to sort of take Singapore maritime arbitration to another level. But it's as I said first, it's all about writing in the clause. I'm just looking at my time. Writing in the clause, but the value proposition has got to be that Singapore is a good, not only location, but a good seat for arbitration. Now, what does that mean? Basically, it means that, when you have to, unfortunately take recourse to the underlying law, you want certainty. You want, and in my opinion, the most important thing is you want an arbitration-friendly jurisdiction. I've been to so many jurisdictions which are not arbitration-friendly. For the slightest of reasons, you just absolutely cannot get your arbitration award enforced, for everything, because it rained on the day that the arbitration award was made. It's something stupid. It's all because, the courts are just so reluctant to sort of embrace arbitration. That's not the case in Singapore. Singapore is an arbitration-friendly jurisdiction. Of course, I know that in London, they go around saying, oh, in Singapore, there's no appeal. Well, who wants appeal? Who wants an appeal from an arbitration? It's a loser who wants an appeal. Winners don't want an appeal. So finality is important. And to get good finality, you need good arbitrators. It's nothing difficult to understand here. And who appoints the arbitrators? It's the parties. The parties. And then these two guys pick a third, right? On the other hand, if you have a situation where the center has to pick, we need good people on the panel, excellent people on the panel, so that they write good, sensible awards. So once you start doing this, arbitration will grow. Mediation, you can go anywhere for mediation, but people tend to follow where the arbitration clause talks of the jurisdiction chosen in the arbitration clause. So people tend to follow that, and so having good practitioners here, and of course you don't need to have a local arbitrator, a mediator. The mediator can come in from anywhere. But to me, when I look at this, mediation for Singapore to grow, then it's, you've got to be relevant. Let's not try to conquer the world. I don't know why we always try to conquer the world. We don't need to do that. Let's just conquer this area, Asia Pacific region, so that they know that coming to Singapore, because you've got parties from different parts of Asia Pacific, where do you want to mediate? Come to Singapore. Will the mediation convention help? Of course it would, but it's not a game changer if you ask me, because we want, that what you want is the recognition that you can get a very good quality of mediation done. So I think I've kind of gone beyond my 5 minutes, but you can be rest assured you'll be hearing from me more. Thank you, Wai Pong.
Thank you very much, Jude, for a very, very impassioned speech. Don't worry about reclaiming your time. We are still within time. I want to reassure my two speakers here. I'd like to move on to you, Ziki. It's your turn.
Hello, good morning to everyone. Yes, I am a claims handler with the Shipowners Club, one of the 13 IG clubs in the world. And yes, my topic would be how suitable is mediation and arbitration in resolving tortious claim? Well, I think it would be a perfectly acceptable proposition for me to say that mediation and arbitration are suitable ADRs for resolving contractual disputes. So there might be some disagreement in terms of some pertinent facts of the dispute, but more often than not, contractual disputes relate to the interpretation of the contractual clauses. In such cases, one could really see how mediation and arbitration are suitable ADRs for handling such disputes. But how does this ADR in terms of arbitration and mediation help in resolving tortious disputes? Perhaps if I could just explain my experience as a claims handler in a P&I Club, I'm sure that, David and Nick here would be able to agree with me on this, that, more often than not, we see a lot of car park scrapes happening in the anchorage, like a low quantum collision contact cases between vessels in the anchorage, minor scrapes. And how does arbitration and mediation resolve such low quantum tortious claim where there is really no contractual relationship between parties? So in such cases, we look, mainly at the duty of care and basically what each party has done to prevent such contacts from taking place. So in such cases, what I really like to do is perhaps to look at arbitration as an alternate dispute resolution. In such cases, I do try to refer such cases to the SCMA CDOC. But what does CDOC represent? It means SCMA, Expedited Arbitral Determination of Collision Claims. So the key components of this new streamlined process include an absence of any requirement to appoint lawyers or to put formal legal submissions. So this takes out a lengthy process that regularly incurs substantial costs. In the absence of these requirements, evidence can be put forth by the parties in the form of experts or surveyor's report. The SCMA ensures that the decision-making process is conducted by suitable, impartial, and renowned experts in maritime law, providing parties with the confidence that any award being issued will be fair and unbiased. Now, we insurers do talk about time efficiency. Just like what David said, we do not like such disputes to be taken, to take place for a long period of time. So the CDOC process provides for very short timelines. The entire process from commencement to the award is done within 3 months. This is a very far cry from extremely lengthy process that many of those familiar with the arbitral and court systems regularly endure. As for the issue of certainty, at the closing of the CDOC proceedings, a final and unappealable award is handed down by the appointed expert. Now, this is vital for small claims and ensures that matters do not drag on forever. The Ship Owners Club, especially for me, I have referred a few cases to the CDOC, and they recently handled a case for ship owners, its members, and it took about 2 to 3 months from start to end. And the legal fees incurred is pretty manageable. It's about USD 40,000 for, say, a quantum of the dispute at stake at USD 70,000. So throughout this whole process, what is most important is how our members feel about this. I'm glad to say that our members felt that it was clear, the outcome was fair, and they accepted the outcome without any reservation. So I do highly recommend the usage of this CDOC arbitration process to deal with smaller collision matters that do happen quite regularly, in fact, outside in our own Singapore anchorage. Now, as I move on to mediation, I think I'll have to touch upon what David said just now. I do agree with him that more often than not, we, the claims handlers, have been often advised by lawyers, hey, let's wait till after discovery before we move into arbitration to try to see how to resolve matters. For Tortious claim, I do think that it's very important to start this process quite early on once the claim has been lodged. And the wonders of being sending disputes to mediation is that the mediator is key to resolving the dispute. A very charismatic mediator would be able to reach a nice conclusion, a fair conclusion to the whole dispute that sometimes arbitration, sometimes a court proceeding or a judge will not be able to do so. Being a mediator means being creative. Sometimes, more often than not, the claimants want more than just a yes or no answer in terms of their claim for monetary compensation. Sometimes they just want to go through and want an explanation as to what has happened to cause, what has happened in terms of, for example, a claimant who has suffered an injury on board a vessel. What went through, what was the thought-thinking process of the ship owner in preventing such a claim? And they do just want an explanation. Sometimes they want an apology, things that a monetary compensation award may not be able to provide adequately for. So for me, humbly, I do think that mediation and arbitration is a great way for resolving tortious claims. Right, I'm done.
Okay, thank you very much, Ziki, and you do raise some really interesting points, especially on tort, which I'd like to revisit later. I'm so glad to hear about CDOC because I unashamedly have to confess that I was the one who conceived CDOC when I was in SCMA. So I'm glad that my child is coming to life. Nick, I'd like to turn to you, not just because you're the last speaker, but as the anchor speaker, so to speak. Over to you, Nick.
Well, thank you very much, and good morning, or evening, or afternoon to those who have taken the time to dial in today. Pleasure to be here, and I'll start off by saying BW is a large ship owner or energy company now. We're a fan. We're a fan of both arbitration and mediation if we get stuck into a dispute. I don't believe that those two methods of dispute resolution are adverse to each other, but rather complementary. And I'll explain why in the context of the ARB-Med-ARB clause, a clause that some of you will be very familiar with, and which was developed here in Singapore, and which we are proponents of. I would also say that we acknowledge the innovation here in Singapore, both in arbitration and mediation. For example, we're keen users of the SCMA as well as the LMAA. And I think if you look at the SCMA new rules came out earlier this year, they are world-class, market leading. And in mediation, Singapore has provided an impetus and an example to the world. So I was going to talk about the Arb-Med-Arb clause, just very briefly for those who are not so familiar. This is a clause which says if you have a dispute, go to arbitration in the normal way. The arbitration is then stayed or stopped whilst a mediation occurs with a person who's different, who the mediator is different to those who are going to be the arbitrators, of course. And if the mediation is successful, then it goes back to the arbitral body, and the arbitral body then creates a consent award which sets out the terms of the mediation. And that was, and if it's not successful, then you just go back to arbitration in the normal way. And that was a great innovation because it made the mediation settlement enforceable under the New York Convention, which, as we've heard, has 163 countries signed up to it. So you knew that your mediation was going to be enforceable, something that's very important in the international context and why arbitration has been phenomenally successful. Is that then still relevant, the Arb-Med-Arb clause, in the light of the Singapore Convention? Well, yes, for at least 3 reasons. First of all, we've heard that 55 countries have signed up now to mediation on the Singapore Convention, but only 10 have ratified so far. We're waiting for the big beasts to ratify, India and China in particular. And so the Arb-Med-Arb clause provides the mechanism by which you can then enforce mediation, as I previously mentioned. That's the first reason. The second reason I really like the Arb-Med-Arb clause is that it embeds in your dispute resolution clause the concept that you're going to most likely have to consider, at least, if not embark on, mediation. And there's an important psychological component there, because the mode of mediation is actually one where the combative stance of your average lawyer is put to one side, and instead the 2 parties who really control the mediation are involved in a joint enterprise, as they were when they put the deal together in the first place, to resolve it. So having in black and white in your document that mediation is something that you need to consider and do is, I've noticed, a psychological component, which is very important. And I do see in many documents, typically joint ventures, escalation procedures for disputes, often, if not always now, contain a mediation element before you get to arbitration. So I think that's very compatible, and it focuses the mind of the disputants in constructive mediation mode from the get-go, despite very conservative lawyers not wanting to embark on mediation until it's too late, which we've heard from some of the other panelists today. Something that I earnestly think conservative lawyers should rethink. The third reason that I like the Arb-Med-Arb clause is that in shipping, we are subject to unusually short time bars by design of our documentation. And therefore, just doing the mediation doesn't cut it from a time bar perspective. So you've got to kind of commence or issue proceedings. So start your arbitration, stay it as soon as you can, then mediate. You've protected your time bar. I think given that the time is going on, I'll stop there because I really wanted to proselytize the Arb-Med-Arb clause and the symbiotic nature of arbitration and mediation. They work very well together.
Thank you very much, Nick. I think that's such a useful perspective, from a user point of view, how mediation really dovetails into the matrix of ADR as we know it, that they are actually complementary rather than mutually exclusive. Ladies and gentlemen, we now move to our next phase of the webinar. We've had such a good input of ideas from my learned friends here, and you could really say that we've a tremendous amount of melting pot of ideas and views, such as we are drinking from the fire hose. Everyone has throttled their input so nicely that we are not overwhelmed. At this point of the webinar, we are going to discuss on some of the ideas that have been put forth. And I must confess that I had no idea what they were going to talk about. All of them being so eminent, they were obviously free to speak on the topic of their choice. I'd like to turn to you first, Ziki, on what you talked about tortious claims. And I'd like to add to it that it's so important to have mediation into the conversation, because personally, I mediated in a case where a crew member actually lost his limbs, and it went to the High Court and it dragged on for 3 years. With little resolution, apart from generating a lot of anger. And when we finally reached the point where the insurer, one of the clubs, agreed to pay the amount that he wanted, I was so overjoyed, and I told the claimant, the victim, that we got what he wanted, and you know what? He refused. I just want to pause here for effect. He refused. And I was shocked. I was totally shocked. And we had to call a halt. I took him out for dinner and I had to ask him outside of the chamber what happened back then. And he came up with some silly excuse. And really what happened was that the injury and all the trouble that the company had demonized him for 3 years. He had almost sort of possessed him, that he was not ready to let go, because he asked me, Mr. Lee, if I accept it, when can I be paid? And I told him, within 3 banking days. He was just not prepared for the immediacy of resolution that mediation offered. He had gone 3 years in the trial with very little expectation of what would happen. And he came into the room thinking that it is just a continuum of his suffering. And when he was confronted by the immediacy of closure, he found that very hard to accept. And I had to assure him that it was all right. It was all right to move on. It was time, in fact, to move on away from the dispute and move on with your life. And that's something I just wanted to share with you, is that quite apart from the sort of contractual written settlement, and I know we talked about enforcement and all that, to him, the actual confrontation with closure that the settlement presented was overwhelming, taken into context the amount of suffering that he'd gone through in the 3 years. So in the morning, he called me up and he said, Captain, I will accept it. I understand where we are now, because he said, I may die, I may die if we continue with the trial for another 2 years, which might go into appeal, I might die. I need to get on with my life. I need to get on with the prosthetics. All that takes time. And I just want to add that as color to mediation. What it presents beyond the printed letter, that actually, and some of you, it actually changes. It changes lives, because mediation focuses on presenting a solution which is right for the parties, instead of focusing on who is right. All right, because in litigation, we are always very, very focused on judging and finding out who is right, who is wrong. But in mediation, for us to be successful, I think we need to be very focused on finding out what's right for the parties in order for them to go on. So there's an interesting interplay between the law on one side and the humanistic elements on the other side. And that's something that that litigation, unfortunately, is unable to take too much recognition of, simply because of the procedural the measures and the law which governs it. Anybody would like to comment on that?
I would agree, because dispute, putting forth such an emotional dispute, if I may say, to a mediator, I think would be more suitable than having it dealt with before a court, where the injured party would be subjected to cross-examination and whatnot, and it can be quite brutal during cross-examination. You wouldn't want to be cross-examined by Dato Jude or Mr. Bazul. You would very much prefer to go before a mediator to explain your interest, not position, but your interest as to, you know, how you feel and why you want to settle.
I see the doyen of shipping in the room. Jude is rolling his eyes to heaven. You like to have any comments on that?
Yeah, actually, you know, while we were talking about mediation, I did have a thought which I was going to share at some point. And I see that there's a question that has come in from someone who says, like, what are the ingredients required for a quality mediation? And I was sort of going to comment on that, so I'll take that on now. Yes. And so I obviously the quality of the mediator paramount, right? Someone who's experienced, who knows how to. Basically, it's a people thing. You know, you've got to be able to handle the people in the room. But from my experience, the biggest problem in a mediation for me up to now are the lawyers. All right. Now it's because by the time you come to mediation, which is why I like it when parties come to a mediator before the involvement of lawyers, but that's very, very rare, right? They tend to come after part, and by this time, the lawyers have already taken a position. They've told the client, you've got a good case, you've got a bad case, 60-40, whatever, right? Now, as a mediator, if you're trying to dislodge that, you get resistance. So, because he's being embarrassed, you know, and then he has to go and privately, he's got to try and explain, oh, you know, why the mediator seems to be thinking along these lines. So I find that on many occasions, I want to see the parties without legal counsel involved. They don't like it, but I find that I get a lot more traction when I have just the sort of parties, and I sort of try and do that because they are also looking. They know that you're a lawyer and that you've been in this game for a long time, so they're looking for some kind of indication. But you don't want to sort of come out and basically say that, hey, whatever you've heard is obviously wrong. So you've got to find that sort of sort of massage the parties to a point where they feel that, like, at the end of the day, nothing is guaranteed. Come on, you can spend a lot of money. I've gone in with what people have told me are rock solid cases and I've lost. Okay, so you have to sort of try and bring at about 9 in the morning, they are sort of both ready to kill each other still, although we're in mediation. But by about 3 in the afternoon, you can start working at trying to chip away at this block because they are also getting tired. And the idea for me is that if lawyers are going to sort of try and justify the advice that they've given, arbitrators have a very, very difficult time. That's my experience. Maybe I'm just not a good enough mediator, but that's the problem that I have, and I find that that's the elephant in the room that I need to work around, and try and bring the parties to some realization that maybe the strict legal position isn't the only thing. For example, if you talk about if they're in an arbitration, many people talk about enforcement of the arbitration award, right? Okay, New York Convention, yes. But at the end of the day, as Bazul said, you have to go back to the jurisdiction and to enforce it. So if I've got a party, I'm not going to name countries here, I don't want to embarrass anyone, but you and I know that in certain countries, it is so difficult to get anything done before the courts. And you may get your award. You know what you can do with it? Go find a good framer, frame it up and hang it on the wall. So that's all that you can do with it. Because if you want to take it back, and you've got to take it back. So at the time of signing the contract, you should also be looking at where do I have to go eventually to enforce this award. Even if I win, then I've got to go into the local legal system of which country. A, B, C, D, E, F, G, every alphabet, I can give you one which I wouldn't want to be seen in, right? So you've got that problem. And if you can highlight this issue in a mediation, suddenly, they begin to think, oh, well, it's not going to end here. If I'm in an arbitration and I win after spending 200,000, I still got another long road to go, uncertain outcome. So you try and chip away at these things. So that's the sort of what I wanted to sort of say. That it's I don't mean to run down the other lawyers in the room, but I'm a lawyer too. But sometimes it's difficult because the mediator is saying something which or is suggesting something that is kind of directly contradicts the kind of advice that I may have given. Passing thought, gents, ladies.
Wai Pong, can I say?
Yeah, I was going
something
to.
in response? Because the only other lawyer in the room,
Yeah.
but thankfully I worked for Jude, so for a few years. So what I'm going to say may not be controversial to him. Now I want to say, respond to David as well as pick up on what Jude said. So there is that. In fact, even Zerky said, why delay the mediation? I am not a fan of delaying mediation until the evidence turn up for several reasons. One is when we're dealing with maritime disputes, the value is small. If the value is a few hundred or even a few million, we're not talking about hundreds of millions of dollars of dispute. Why delay? Why run up costs? And we also are in a legal system, London, Singapore, New York, where the approach is cards on the table. You don't hide your main arguments until the eve of the judgment. You are expected to put all arguments and evidence in at the time when you launch your claim. That's the approach courts have taken. So there is no capital or profit in holding back or wait until the evidence turns up to mediate. And in fact, mediation is an excellent opportunity to deal with where the issues lies and declutter the problems and come up with a settlement. Now, I'm going to touch on what Jude mentioned in terms of Now, I did say that whether it's mediation, I did focus on mediation in terms of the human element, human story coming into play. But even in litigation, there is always a human story, a human element. Sometimes that overshadows the commercial objective. So a good litigator, a good mediator would be able to, or mediation counsel will be able to declutter that. And when we are dealing with a commercial dispute, it's also not very difficult to unpick what is the objective and what are the stumbling blocks in reaching that objective. It's a commercial analysis. How much cost it will take, how much it will cost to enforce, what is the risk of it turning up into a picture frame as opposed to monetizing the award. All these are not secrets. Anyone in the room and everyone in the room will be able to explain that with clarity. So my settlement record is about 80%, which I think is fairly high. So I think it is important. I think what needs to happen is going forward in the future, there need to be more training for mediation counseling. I think that's what needs to happen. It's a new approach. I am going to advocate that going forward.
Thanks very much, Bazul. You'll be relieved to know that actually I'm a coach for the Part B mediation advocacy at the SMC. Jude and Bazul, thanks very much. I think you all raised some very, very important points. And if I may, I'd like to contribute some points of view. Firstly, on the role of lawyers, I'd like to cite a case. I was very, very fortunate to mediate in 2019, I think the largest case for SMC running into triple-digit millions. And there were 11 lawyers in the room and just me. I have to concede that if not for the lawyers, we would not have settled. Right? This arbitration case had gone on for a couple of years. and it was. I want to bring this up because at that time, this has relevance to when is the right time to mediate. I think that if they had tried mediation earlier, it wouldn't have worked. I think it took 3 years for all the issues to be nicely crystallized, for the parties to really process it and understood that maybe it was the right time to mediate. And the fact that we had 11 lawyers in the room, both general counsel, house counsel, counsel and their associates, all in the room together with their clients, everybody worked towards the resolution. I couldn't have done it on my own. So just to offer an alternative view, really is my experience that in all the mediations that I've successfully mediated, I always feel that I could not have done it without the counsel. There was only one case where counsel actually could not manage his client, and then I had to take the client outside and give him a heart-to-heart talk, and after that he settled. But I mean, quite apart, quite different from your view, Jude. My personal experience, however limited, is that I find counsel. I think this has a lot to do with what Bazul mentioned. Counsel who are schooled in mediation advocacy are tremendously helpful towards the resolution of the process.
So can I just chip in here? I wanted to comment on something that Bazul raised, which I think is very important, and that is what universities and law schools are teaching. And we had a look at what the main law schools are teaching in Singapore and elsewhere. And there's a lot on arbitration. There's relatively little on mediation, although it's improved. Certainly when I was at law school, I hadn't hardly heard of arbitration, let alone mediation, but Singapore has been quite innovative at the universities here, but the rest of the world has some catching up to do. And attitudes are shaped by young lawyers from their education. And so the more we can get mediation as an alternative dispute resolution that's recognized, the better. Yes. So I fully endorse that point. Are we still online?
No, we're taking some questions that are flowing in as we're having our chat. And actually, I want to turn over to you, David, and your interesting concept of the conveyor belt. There's a question from the floor amongst our audience. Is there any common policy between the IG group of P&I clubs to encourage external lawyers to use mediation or ADR for shipping disputes? Actually, I like to put it to both the clubs. I have to disassociate myself from UK P&I Club since I'm the moderator. I would like to have first, David, your view, and Vicky.
Sure. Well, there's no agreed formal policy between the international group P&I clubs to do that. But I think it's fair to say that I'm sure all clubs in the group would share with us the view that we should be encouraging external lawyers to promote mediation and certainly consider mediation on a case-by-case basis to our members who are in dispute. So that is something that, it's also the role of individual club claims handlers to actively raise this with lawyers. Even if the lawyers don't raise it, then the club should be asking the lawyers, why are they not considering this? Now, sometimes you will get a whole range of reasons back from the lawyers to why mediation is not appropriate. And it is the club's role, if necessary, to challenge that. I mean, we ultimately, although the lawyer is not technically instructed by us, we are the funder of litigation and therefore have a significant say in what happens. Clearly, it's collaborative in that it's extremely important that we bring our members along with us, and we will consult our members as to what they think is best. But a number of panelists have alluded to the risk of lawyers sort of stirring up and winding up the member in terms of thinking they've got a great case and all of this. And it's just really a question of trying to calm down, pause, consider what the right thing is. I do, by the way, Nick, very much agree with you with your mediation arbitration clause point, and the point you've made about the symbiotic relationship. it's clearly not a one size fit for all. One of the challenges I'd just like to raise, Wai Pong, is that is how to get these clauses into the contracts, because I'm afraid often charter parties and other maritime contracts are churned out by brokers, and I think too little thought is given to what goes into these clauses. And I think it's fair to say that there are relatively few media arbitration clauses being used. In fact, one might even say hardly any. It's great when you see them, but why aren't they being promoted more? And there is a role for ship brokers there too, to consider that, and insurance brokers.
Yeah, being the only shipping person in the room, I can, my opinion is that there's zero thought being given to the dispute resolution clause. They're too generous with a little bit of thought. Ziki, over.
I would agree with David. It's really up to the individual claims handlers to decide what's the best way forward. But for the ship owners, we do look at a variety of factors. We look at the complexity of the dispute. If it's a very complex contractual dispute, perhaps the right time would be after discovery. But more often than not, if it's a tortious dispute, where there is a dispute about facts, the duty of care, etc., with some human elements, stories, emotive feelings involved, definitely I would kickstart mediation quite early on in the dispute to prevent it from snowballing. But more often than not, we've seen quite a few cases go for mediation. I think recently I handled one ship repair versus dispute with a shipyard with SCMA, and we did quite well. We settled. So quite happy with pushing forth this agenda, this proposition that, most cases, we should try out mediation.
If I can just jump in here, I think at least within the framework of arbitration, one of the challenges is that you don't often get arbitrators who are prepared to direct parties to go for mediation. That is typically a power that is silent either in the arbitration institutional rules or within whatever agreement that you have. And sometimes really the arbitrator might be in the best position to assess when it's appropriate to go for mediation. And I think that is a gap that institutional rules at least could well address, because in the few occasions where I've seen arbitrators direct mediation, they've generally been quite successful. So I think that's an area to explore. If you can't get it into dispute resolution clause, the question is, can you get it into the arbitration rules that you're using in order to try and facilitate mediation coming in an appropriate juncture of the arbitration process?
That's a really interesting point, Delphine. Actually, from my personal experience, I mean, I mediate in a lot of high court cases, and often the judges themselves instruct the parties. I think you all should, take a few steps back, pause, regroup, and maybe look at mediation before going on any further. And that's not mirrored, as you rightly observe, in the arbitral process. So that's something really worth considering. Delphine, I want to touch on the point that you made. I was quite astonished that in 2020, the amount of trade-related and shipping-related cases for SIAC, right, rose to 70%. That's actually quite eye-popping. Suggests that there's a rich minefield for mother lode of opportunity for mediators like ourselves. But the thing that caught my ear was this statement you made about the integration or the merger between the EMAC and the DIFC into a single DIAC. And you cited there's a move intended to strengthen Dubai's hand. Do you have any thoughts about Singapore? Of course, in Singapore, it's undeniable we have many bodies, somewhat diffuse, or one of a better word. Do you have any thoughts about, is this a good strategy, or we're better off, having the institutions as they were functioning on their own?
Yeah. So I think come from an institutional background, I think there are far too many abbreviations in the ADR landscape in Singapore. you have SIAC, SCMA, SIMI, SIMC, SMC, and CIDRA, and then you have Maxwell Chambers. So, and all these serve really the same landscape, the same spectrum of users. There is, at least at SIAC, there were a number of engagements with fellow institutions where we try and market together, where we try to outreach together. But it's not as effective, at least in my view, when institutions come from various interests and where there are various factors that are motivating their actions. I strongly believe that there will have to come a time where the institutions have to amalgamate, where you take advantage of economies of scale to really put forward that ADR product internationally. Tying back to the mediation question, so one of the challenges, as I said, you don't often see arbitrators referring cases to mediation. And I suspect part of that challenge is really because SIAC is separate from SIMC, is separate from SMC, so that referral process is unless you can get some kind of agreement with the parties, it's difficult to make that kind of referral. It's challenging to try and persuade arbitrators to make that referral. And I do think offering this suite of services, ADR services under one roof, the same way how the ICC does it and the HKIC does it to a certain extent, I think that is beneficial. Just to touch briefly, I think Jude mentioned the point about competition. I think that sometimes it's not so much that we want to compete, but other people want to compete with us. I think Singapore has been particularly successful when it comes to establishing ourselves as an ADR center. And I think that's not just because of the ADR product itself, but also because arbitration mediation, any form of ADR that comes internationally into Singapore, you're looking at a lot of knockdown economic gains. You're talking about hotels, you're talking about spending, you're talking about airlines, you're talking about all that. And that's why I think a lot of countries are looking to grow their own ADR centers. And really, ADR services, it's not difficult to offer arbitration services. It's not difficult to offer mediation services. What really distinguishes, in my view, one institution from the other is the quality of the panels, quality of mediators, quality of arbitrators. If it's an administered arbitration, quality of the secretariat. On top of it, as Jude has already pointed out, it's about enforcement. It's about whether or not you can get judgments back. You can get Singapore as a financial center. That I think is a big factor for parties choosing Singapore as a seat. And really, we are fortunate in that legislating in Singapore is a fairly quick process. So we went from no third-party funding, no success fees, and in the just like last 4 or 5 years, we now have third-party funding. We now have success fee arrangements which are allowed within the context of international arbitration and mediation. So I think Singapore continues to innovate. There are other jurisdictions who have looked at Singapore as a model to follow. So there is that competition, whether or not we want it.
Okay, thanks very much, Delphine. Jude, I have a question for you from our learned friend Aziz Dayabali, whom we both know well. It says, Wai Pong from one mediator to another. I have a question for my good friend Dato Jude Penny. Would he not agree that when his client and he agreed to mediate, he as counsel cannot go into a mediation with a set mind about what he has advised his client, but rather also be prepared to alternatives suggested by the mediator? Would you like to respond to Aziz?
Yeah, that's a typical Aziz Tayabali question. But yeah, I mean, it's sort of it's not one size fits all. I mean, I've come across people with a myriad of approaches, right? They come into an arbitration. So I think when counsel and parties, well, sometimes the courts force you to, so you just have to go anyway. But on the other hand, if they, once they are there, or if they voluntarily go into it, of course, you want them to come with the right mindset. And generally, when sometimes when a lawyer feels that he's got a fairly strong case, he's going into the mediation with the perspective of trying to convince the other side that really you should pay up. We'll give you like a 10%, 15% discount, but really you should pay up. The other side, of course, has got a completely different perspective. So the arbitrators' role, and I would agree, is to try and chip away at both of these sort of views, which some hold very strongly, some come in sort of a little mushy around the edges, and you feel that you actually can bring them closer slightly more easily. So it's by no means am I suggesting that all lawyers go in not willing to sort of find a solution. Absolutely no. There are lawyers who come in with the right mindset, and there are some lawyers who come in with the wrong mindset. I know lawyers who go into mediation simply because in the early days, before it was all sort of all evidence up front. In the old days, we used to do it just to flush out all the evidence on the other side, and then say thank you, bye bye. I'm going to continue because it looks like I still have a good case. So that's a wrong mindset, right? So different people come in with different mindsets, and I think there is a lack of education, and I agree with what Nick is saying and what Bazul hinted at also. Severe lack of education in terms of how to be a mediation counsel. I think that those are courses worth attending or running, and I think even for seasoned practitioners, because at some point in time you're going to have to sort of go down the mediation route. And many lawyers, just like many lawyers think that they're great advertising guys or PR guys and they can handle everything for the firm. But so a lot of lawyers seem to think that they can do mediation. What's the problem? Mediation, yeah, I'll go there and mediate. There's a lot more to it than that,
All right, thanks very much, Jude. I'm sorry I have to cut you off there. We're running out of time. Ladies and gentlemen, distinguished speakers, thank you very much. I thought we had a really, really good dynamic discussion this morning. Before we end, I just want to sort of ask all of you to reflect, having tasted the melting pot of ideas, each of you to reflect and in a sentence or two, come back to me on either of these 3 points I want to pose to you. As far as Singapore's role in maritime dispute resolution, either what has changed for you, what changes you would like to see, and finally, what must not change, either one of these. I'll start with you, Bazul.
Thank you. So I am a big fan of diversity. So that's what I want to see going forward in the future. I want to see different mediators stepping in, gender, race, cultural differences, with the cultural differences stepping in to mediate. I think that's super important to effect a settlement, right person for the right dispute.
So no one size fits all. David, now move over to you. Any of this? What has changed? What changes you'd like to see, or what must never change?
So for me, it would be the change of mentality. I think all parties, all stakeholders, whether it's insurers, lawyers, end clients, ship owners, etc., all need to consider the option of mediation as early as possible in the piece. And I think that should be in the sort of process that you go through when handling a dispute, that should be very high up on your checklist of things to do. So it needs to be raised up the agenda. The second thing is, in the context of Singapore and the mediation, arbitration, mediation clause, I think ship owners and charterers should very much consider talking to their fixing brokers and ship brokers and getting these clauses put into the contracts, because I would argue that it's quite difficult to disagree that such a clause is a good thing. What is there to lose by having it, and there's potentially everything to gain.
Thank you for the takeaway. Delphine?
I think one is, which I mentioned earlier, I think that there needs to be more uptake or more recommendation of mediation by arbitrators. So whether or not through change of institutional rules or education, I think that's something that mindset has to change, whether with or without the supporting framework. The other thing, which is my pet topic at this point, is I would like to see AI being used a lot more. You're seeing arbitration in particular being adopted by big organizations, and arbitration is bloody expensive. I say that, and it's become a dispute resolution mechanism that may be out of reach for the masses. And I think that it is important to consider what can be done to improve access to arbitration, whether or not through small claims, general small claims procedure, or even AI-based dispute resolution. I think that's really the next frontier for ADR.
Okay, that's something into the future, Ziki.
I think that must not change is for Singapore to retain its policy to attract talents. Arbitration mediation is all about the mediator, all about the panel, the arbitrators. You know, we have talented mediators, really good arbitrators, and we as claimants or, you know, defendants, we believe in them. That's the only way to make mediation and arbitration flourish in Singapore.
Okay, thank you. What about you, Nick? You're the host.
I think keep the innovation going in Singapore. That's what I would keep. It's amazing how supportive this ecosystem is towards mediation and arbitration. Keep that up. It's going well. Secondly, I would say remind business folks and ourselves as lawyers that mediation is a forward-looking process. Arbitration and litigation are backward-looking processes, and mediation you can bring in solutions that you cannot bring in the other forms of dispute resolution. And remind people that the mediation has an 80+% success rate. By definition, arbitration and court proceedings have about a 50% success rate.
Thanks very much. I'm looking at Jude and he's thinking, oh my God, did my friend forget me? And of course not. Of course not. You are the doyen in the room, Jude. So I thought I'll save the best for last. Jude, over to you on.
Okay, just a quick one. I think what does not change is that, you know, I'm going to speak from the arbitration perspective, since everyone's already spoken a lot about mediation, is that we just have to remain a very arbitration-friendly jurisdiction. And from that point of view, they must, I think the courts need to refrain. And so this is, you know, I'm seeing a trend where they are looking at some awards, and there have been some successful challenges. I don't particularly agree with all of that. I think, you know, parties choose the arbitrator. They've got to live with the choice that they've made, unless there's been a very, very serious breach of natural justice, something like that. So I think Singapore needs to show that we respect arbitration, arbitrators, and the process, and hands off unless it's absolutely required. And I think that's important.
All right, thank you for your closing remark. Ladies and gentlemen who have tuned in, thank you very much for sharing with us this past 1.5 hours with my learned colleagues here. I think we've had a very interesting interplay of ideas and experiences. It's been very, very dynamic. I personally felt so. All right, and I want to thank you on behalf of the team here for spending the time with us, and also to Nick for kindly allowing us to use this very nice room here. It remains for me to hand the webinar back to our very generous host, Ms. Bernice Yeo. Bernice, would you like to close the seminar, the webinar?
On behalf of the SCMA, I would like to thank Mr. Lee Wai Pong, as well as all the panelists for enriching and also engaging discussion. And to those who have dialed in, thank you very much for your participation. In the meantime, do take care and find some time to check SCMA out on our website as well as LinkedIn. The next slide would actually indicate all the details that you will need. Yeah, and please fill in the feedback form. Thank you very much for your participation. Goodbye. Thank you, everyone.